everybody. It's Yaasha Sabba from Sky Unlimited Legal Advisory. We're here for another episode of Ask Me Anything. Sorry, I've been away for a while. It's just gotten really busy now that things are opening back up. Everyone's getting their shots. Some people are not. So why don't we start with your estate planning, asset protection, and probate questions. All right, question number 1. What type of documents would I need to appoint a guardian if I were to pass away today? I'm a single mother and my daughter's father is abusive. Oh my gosh, I'm sorry. Would I need an attorney for these documents? What type of documents would uphold in court? And how can I avoid guardianship going to my daughter's father, who has a long history of domestic violence towards myself and another female? So here's the thing. Courts generally do not like breaking up families. So if you believe that if something happens to you one day and you don't want your custody of your child going to her biological father, that's going to be very hard to do unless the father already doesn't have custody, such as you got divorced, or there's a restraining order against dad for so many other reasons. You'd be surprised this stuff happens. It's kind of sad how families go through this much turmoil. One thing you can do is always, if you just feel like the biological parent does not have the ability to be a good parent and protect that child and financially take care of that child, you can name alternate guardians. You can nominate guardians. So only a judge actually appoints the guardians. Nobody else can do that but a judge. But you, as the parent, you most certainly can nominate guardians and give an excuse to the judge, reasons on why you believe these guardians should be appointed to take care of your child when you are gone and not the other living parent. It's not easy. Courts, judges, they generally do not like to break up families. It creates more problems when children are not with their biological parents. But if father was abusive, and if he was abusive to multiple people and you don't want your child raised by someone like that, you can create what's called a confidential exclusion of guardianship. This is a separate document that I generally help my clients create, where they can privately on a separate document say, here's who should not be guardian. Here's who should not be the parent of my child if I can't be, for all of these different little reasons, okay? And what happens is when you die, or you pass away, or you're incapacitated, you can't be parent anymore, your guardians will take their nomination to court. They will ask a judge to appoint them, and the judge will say, where's the other parent? And you'll have to give notice to the other parent. The other parent will come in and be like, what the heck is going on? Because the law doesn't necessarily say that the other parent loses custody unless you create some kind of case against that parent. But remember, when one parent dies, the other parent is the biological parent. They're the child's parent. There's no legal maneuver they have to do. So if you don't want dad being the parent anymore, and if he hasn't lost custody prior, like during a divorce hearing or some kind of parental abuse case, then you're going to have to actually build a case against dad saying that he's not fit to be a parent. And that usually requires involving other government organizations. It's not just something you can go to a judge and say, hey, remove custody from him and give custody to me. So it's not easy, but it is possible. And you can, at the very least, make your wishes known on legal documents. It's probably not something you should do yourself. My recommendation is you reach out to an estate planning attorney or even a family law attorney, someone that has handled guardianship cases before, and you can at least put your concerns and wishes for alternate guardians on paper so that if that day ever does come, there's more ammunition when the court and the government hears your words when you're no longer able to convey your wishes. So I do think that's a great idea. Next question. What estate planning documents should my son, who just turned 18 and is planning on attending college this fall, have in place? The moment your kids turn 18, they're legal adults. What does that mean? It means you no longer have the ability to have a say over their lives and affairs. Huzzah! Isn't that nice? Isn't it true? Like, some parents don't like this idea. And in my mind, are you trying to hold on to your children for the rest of your life? Or are you trying to let them leave the coast so that you can go on those retirement vacations, So there is a balance that we want in life. But keep in mind, if you feel like your children are too young or too adolescent at the age of 18, guess what? The law says no. The law says they are adults. And if something happens to them, if they end up in the hospital, you don't have a legal right to have a say over what happens next. You're an interested person, so doctors will listen to you. But if, let's say, their girlfriend has a differing opinion, now you don't have a say, they don't have a say, you all have a say. And the fact that you're your child's parent means nothing because they are legal adults. The parentage breaks from there. So what does your child need? Your child needs most certainly an advanced healthcare directive where maybe they can list you and nobody else as their healthcare agent. That gives you the continued authority just like you would have had if you were a parent. The next thing is a financial power of attorney. This is a power of attorney. We kind of all know what that is, but it's a legal document where your child names you as their agent to act on their behalf when they can't in order to handle their finances, their affairs, their estate planning, pretty much anything. You can get a power of attorney to get a mortgage for your child, open up a loan, apply for Social Security. So those are very powerful tools in the event that your child has no estate plan otherwise, no trust, no will, nothing else. And you just want something simple that will allow you to continue supporting your child as they grow up into full adulthood. And what I think about that is financially literate kids, right? No one at the age of 18 knows how to handle money. Let's face it, right? So from there, those are the two key things that can help protect you. But at the same time, if you really want your child to become financially literate, if you want them to become responsible adults and make great decisions, it's my belief that you should start at the age of 18 of introducing them to very much adult concepts, applying for loans, debt, credit cards, estate planning, building a will, building a trust. These are some things you probably don't have. Do you have a will or a trust? Are you truly an adult? Do you have people you want to protect? Do you have a family? If you don't have those things, you're failing at being an adult. As cold as it can be, you're failing, right? So in order to succeed, take care of all of this. And the best way for you to take care of it yourself, you can bring your child along with you and help them take care of it for themselves as well. Think about that.